There's multiple allegations of misconduct.
Still drinking or not drinking at all?
Not drinking at all.
And how long has that been the case? This is a virtual hearing of Ingham County Hearing Panel number 2 of the Attorney Discipline Board of Michigan in the Grievance Administrator versus John Lawrence McDonough, P number 68576. And it's in case numbers 24-27MZ, which is reference 22-83-JC, and case number 24-45-GA. The panel is composed of Lori McAllister, myself, chairperson, Roman J. Tiskavich, member, and Charles M. Krasanik, member. The panel has been appointed by the Attorney Discipline Board, which is the adjudicative arm of the Michigan Supreme Court for the discharge of its constitutional responsibility to supervise and discipline Michigan attorneys. Counsel for the grievance administrator is Austin D. Blessing Nelson, who will present the case for the Attorney Grievance Commission, a separate branch of the Michigan Supreme Court for the investigation and prosecution of discipline matters. As this hearing is being conducted via Zoom, hosting controls of the meeting will be performed by the board's case manager. The hearing will be live streamed on the board's YouTube channel. The parties are asked to avoid excessive overtalking and interruption to keep the proceedings moving smoothly. This hearing will be conducted according to MCR 9.115, the rules for circuit court bench trials, and Michigan Rules of Evidence. Before the panel is a consolidated formal complaint and a motion for order to show cause. Regarding formal complaint 24-45-GA, the hearing panel must first determine whether misconduct charged in the formal complaint has been established by a preponderance of the evidence, by respondents' admissions, or as a result of respondents' default for failure to answer the formal complaint, MCR 9.115J. If at the conclusion of these proceedings, the panel determines that misconduct has not been established, the complaint will be dismissed. The burden of proving the allegations in the motion rests upon the administrator. The hearing panel will first determine whether misconduct alleged in the motion has been established by a preponderance of the evidence or by respondents' admissions. If at the conclusion of these proceedings, the panel determines that misconduct has not been established, the proceedings will be concluded and the motion will be dismissed. Upon a finding that the misconduct alleged in the formal complaint or the motion has been established, the hearing panel will continue the hearing or conduct a separate hearing to determine the appropriate discipline. At that time, the panel will consider evidence which is admitted for the purpose of showing mitigating or aggravating factors. The decision of the panel may be appealed to the Attorney Discipline Board by the grievance administrator, respondent, or the complainants. We will now proceed with the hearing. So at this point, we would start with opening statements. We would start with Mr. Blessing Nelson with your opening statement. I understand that Mr. McDonough is wanting to make a motion, so we should probably get that out of the way first.
Yeah, I was going to say, usually, we deal with preliminary matters first, and I would say that he should go first on that.
So Mr. McDonough, if you would like to make your motion.
Thank you, Ms. McAllister. And again, I apologize to Ms. McAllister, and I'm apologizing to the rest of the committee. I would have dressed much nicer, but I forgot to bring any nicer clothing with me. I am in a hotel in Iowa for my daughter's national softball tournament. But at this point in time, I haven't asked for an adjournment yet, and I would ask for an adjournment at this point in time. This morning was the first time I had an opportunity to review the exhibits for both the misconduct and the sanction. I didn't receive them in mail until the end of last week. I was on vacation last week. They were mailed on the 2nd, and I think I got them Thursday or Friday of last week. And I was, as I said, I was on vacation last week. My son had baseball all weekend, and we traveled here on Wednesday for the beginning of this tournament. So I would kindly ask for my first adjournment in this case, and would ask for 2 to 4 weeks to have an opportunity to review everything, speak to counsel if I think that's necessary, and then I'd be happy to move forward with the hearing.
Response?
Yes. First, just to clear up something, it is true that they were mailed to him on July 2nd. However, they were with the potential exception of Sanction Exhibit 5, which was served at a later date, but that's just the prior order of discipline. All the exhibits were sent to him via email on July 2nd. So the argument that he didn't receive them until recently is kind of a little bit not true. Regarding the request for an adjournment, so it's worth bringing to the panel's attention that Mr. McDonough actually emailed myself and Jody on the 10th of July, saying, quote, "I wanted to let you guys know that I'll be filing a motion to adjourn Friday's hearing. I will be in Iowa. My daughter's softball made the national tournament, and they have games all day on Friday. Sorry for the inconvenience, but this was a lifetime opportunity."
Mr. Blessing,
quote.
Mr. Blessing, you
Yes.
read that so fast that it was very difficult to understand you. So could you please kind of slow that
Sure.
down?
I
Thank you.
can
I'm sorry to
repeat
make you
too.
do that again.
I wanted to let you guys know that I will be filing a motion to adjourn Friday's hearing. I will be in Iowa. My daughter's softball made the national tournament, and they have games all day on Friday. Sorry for the inconvenience, but this is a once in a lifetime opportunity. I responded, thanking him for the heads up, requesting that he file his motion that day so I had time to respond to it, and that he show proof to the game. On Thursday morning, the 11th, I asked him if he was still planning to file his motion, and he responded, quote, "No, I am not. I was under the impression that my daughter's first game was 10 a.m., but it isn't until the afternoon. I am completely new to this. How long do you expect it to last? Will a decision be made tomorrow? Attaches her game schedule," end quote. He attached a screenshot of the game schedule that was sent to me and Ms. Groh, the case manager. I reasonably took that to mean he was not seeking adjournment anymore. Him and I emailed back and forth a little bit about how long I thought this would take, what I'd be presenting, and potential sanctions I'd be reaching. In those discussions, he never again indicated he'd be asking for an adjournment. By all accounts, he said he was ready to move forward. Quite frankly, him coming here today and asking for an adjournment is untimely. It should not be granted. Petitioner is ready to move forward. This is simply another delay tactic, as has been not responding to the motion, which he was ordered to do by April 22nd, yet he still hasn't, which means, as I'll argue later, that the motion is not contested and should be granted. He's also, as evidenced by the default, which I will enter the exhibits for at the appropriate time, not respond to the formal complaint. He's had more than adequate time to do all of those things. The fact that he now shows up and now wants to seek the advice of counsel and now wants to try to participate, now wants to answer the formal complaint, it's too late. This is an untimely request and should be denied.
Okay, thank you, counsel. Any reply, Mr. McDonough?
Oh,
Well, under the specific rules here, it looks like the panel needs to consider it. So Jody, can you please put us in our separate room? We will deliberate, and come back into the group room in a moment. So if you would stand by, we will be back with you.
Oh, one moment.
Council, if you want to return, we are back. Mr. McDonough, we've considered your motion and we are denying it. We do not believe that it comports with the time requirements for filing such a motion. Furthermore, we believe you've had ample notice of this hearing and time to prepare for it. The exhibits have been provided to you in a timely manner, and so we are ready to proceed. So, Council, if you'd like to proceed with your opening.
Sure. Well, at this time, I would actually move for the default by going through those exhibits. If it pleases the panel, I would like to move for the admission of petitioners. Where did I put that? Petitioners proposed misconduct exhibits 1 through 5 relating to the default and the show cause motion.
Okay, these are ones that were provided through, let me just make sure we all have.
They were both emailed to him and mailed to him and provided to the case manager, yes.
Yes, okay. I just want to make sure that we all have the same ones in front of us. I believe we have them all. Any objection, Mr. McDonough?
No.
Okay, exhibits 1 through 5 are admitted.
Thank you. And just to make sure the record's clear, that's the misconduct exhibits, not the sanction exhibits 1 through 5. Just perfect.
And we should probably indicate that those are in support of which case?
They are in support of both cases. I'm about to address that when I have to formally move for the default to be entered and
Yes.
briefly address the motion. Yeah.
Okay.
So as exhibits 1 through 3, which have just been admitted, show, respondent was properly served with a formal complaint, yet he failed to answer it. At which time the grievance administrator filed and properly served upon respondent a default. Sufficient proofs have been submitted to demonstrate that service was proper under MCR 9.115C, which requires service of the complaint and default by registered certified mail at respondent's last known addresses on record with the State Bar of Michigan. Service is effective at the time of mailing, and non-delivery does not affect the validity of service under MCR 9.115C. Despite being properly served, respondent has not filed an answer or taken other action within 21 days of service as required by MCR 9.115D1. Having established that service was proper, and because respondent failed to answer the formal complaint, the grievance administrator requests that the hearing panel make a formal finding of default pursuant to MCR 9.115D2. Further, as a default constitutes an admission of the charges of misconduct, the grievance administrator requests that the panel enter a finding that the allegations of misconduct contained in the formal complaint have been established by preponderance of evidence by virtue of the default and the allegations that have been admitted through said default. Somewhat related, regarding the show cause motion, which is supported by exhibits 1, 4, and 5, which were attached to the show cause motion, respondent was ordered to respond to that motion by April 22nd, 2024, but failed to do so. His failure to respond leaves the facts uncontested, and petitioners are entitled to the relief requested, namely a finding that he violated the conditions of the order of reprimand and that additional discipline should be imposed. When I address the sanctions for the formal complaint, I will address what level of discipline should be imposed regarding the show cause motion. At which point I would ask, at this point rather, sorry, it is Friday. At this point, I would ask both that the default be formally entered and that the show cause motion be granted, and that we immediately move to a sanction hearing regarding both the formal complaint and the show cause motion.
Okay, Mr. McDonough?
I don't have an objection to anything other than the fact that I would ask that the sanctioning hearing be done on a different date. I would like ample opportunity to prepare for the sanction hearing. It is my livelihood at stake, and I would like the opportunity to be able to have and been able to formally prepare for that. This is the first time I've been through any sort of hearing in front of the Grievance Commission, and it's not something that I'm familiar with. And I understand that Mr. Blessing Nelson is asking for, will be asking for sanctions above and beyond my initial agreement with Mr. Novi and Ms. Burgess. And I would like to have the opportunity to review everything and prepare arguments for the sanction hearing, but I do not have any objection to any of the other items being admitted.
Mr. McDonough, help me understand, you've had notice of these motions and notice of this hearing for months now. Why are you not prepared to go forward today?
I thought today was the proofs portion of it. I didn't realize that a sanctioning hearing was going to happen. And if I received notice and I didn't properly look at it, I guess it's on me. And, you know, we can move forward. As I said, it's my livelihood at stake. And this is the first time that I've been through any sort of disciplinary hearing. And, you know, I'm not exactly sure how everything works. So if
Didn't you have
I see Mr. Blessing Nelson hustling to grab paperwork and other things, I'm not denying that I was given proper notice and service of everything. I guess I don't have much of a response other than this is my first time and I didn't understand what exactly I needed to have prepared for today.
Didn't you have a hearing in connection with your last discipline?
Not in front of the board, no.
Okay.
Mr. McDonough, do you have no objection to the default?
I do not have an objection. I'm not denying the allegations that have been brought in front of you.
In light of that, panel, do we need to confer separately on this, or do we accept?
Just before you do, I just want to briefly state, just to actually support Mr. McDonough, the prior discipline you're referring to was by consent, and while I did not personally handle it, it is my understanding that there was not a hearing in connection with it.
Okay, thank you. Appreciate that clarification. I think the based on the admissions that we have here today and that have been made, the panel can declare the default entered and misconduct found by the entry of that default, and that the show cause motion is granted. So the issue then is whether we proceed with the disciplinary hearing. And again, Mr. McDonough, we think that you've had ample notice that that was part of today's proceeding in the event that there was misconduct found. So we will proceed.
Thank you. I have a brief opening and then I have 2 witnesses to call.
Okay,
If
please proceed.
that's how we want to see. Okay. I'll keep it extremely brief, as the panel has found both by default and the show cause motion. Mr. McDonough has been found to have mishandled a client matter, failed to answer a request for investigation, and then improperly tried to get that request for investigation dismissed. He also failed to comply with orders of a prior discipline. These both show a lack of understanding of the rules of professional conduct and a lack of care for it. I will go through the applicable standards as part of my sanction argument after testimony, but I will be asking for a suspension in excess of 180 days, and ask that before he can be reinstated, Mr. McDonough be required to undergo an LJAP assessment and complete the State Bar of Michigan's Tips and Tools for a Successful Practice Seminar. As you will hear today, restitution is not an issue. The victim has been repaid. At this time, prior to testimony, if it pleases the panel, just to streamline these proceedings, I would move for the admission of petitioner's sanction exhibits 1 through 5. I could do them one at a time, but to streamline the proceedings, I would move for their admission right now.
Any objection, Mr. McDonough?
No.
Exhibits 1 through 5 for the sanction portion are admitted.
Thank you. And just a quick note, when I originally filed the exhibits, it was 1 through 4. Exhibit 5 was filed later. They should all be in possession of the panel and the respondent, but just wanted to note that if you're looking at the original packet, Exhibit 5 was filed separately.
We have it. Thank you.
Perfect. At this time, I'm ready to call my first witness. I believe Mr. McDonough, if he may or may not have an opening statement. After that, I'm ready to proceed with my first witness.
Okay. Mr. McDonough, would you like to give an opening?
As I've previously stated, I'm not sure how this works. I'm assuming I'll be able to give a statement at the end regarding my position on the issue.
You can give it now or at the end, whichever.
I'll choose to wait.
Okay.
At this time, oh, I'm sorry.
That's okay.
I'm so sorry. At this time, petitioner would like to call Mr. McDonough.
Okay. Would the court reporter please swear in Mr. McDonough?
Would you raise your right hand, sir? Can't quite. You look frozen. There you go. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Hang on, just one. Sorry, someone was at my door. I was just telling him I wasn't hearing. Good morning, Mr. McDonough. Could you please state and spell your name for the record?
John McDonough, John, McDonough.
Thank you. How long have you been licensed to practice law in Michigan?
Since November of 2005.
Thank you. Is it true that an order of reprimand with conditions was previously entered based off a conviction for your conviction for impaired driving?
Yes.
What were the conditions of that order?
Without them specifically in front of me, are we talking the initial one?
I guess I should back up. Have you ever been convicted of impaired driving?
I just said yes.
Okay. At which point, did the Attorney Grievance Commission take any action against you regarding that conviction?
They did. It took them a year, approximately a year, after I filed notice to them of the charges against me to do anything, but yes, they did. I had entered a guilty plea and was on probation with the district court in Kalamazoo County. When I started with the LJAP program, as a part of the LJAP program, I had to go through an assessment. I had to do Alcoholics Anonymous, have a sponsor, do random drug testing. Dana Richards was my supervisor. I completed everything and then some for over a year. Then had a relapse. Was ordered to go to North Carolina to Pavilion for rehabilitation, which cost me a fortune out of pocket, money that I did not have. I asked Mr. Richards if I could please wait to have my feet taken care of medically before I went down to North Carolina to Pavilion. He said no, that I could lose my license if I didn't go immediately. So I went, my feet got more infected, and I've lost 4 toes since then. After getting back from Pavilion and having my toes amputated, I relapsed again, and that's when I got involved with Mr. Novi and was signed the agreement to do the counseling, testing, everything, counseling, testing, AA, find a sponsor, stay abstinent, do the affidavits with Miss Burgess. I did one affidavit, I believe, to her. I went to counseling for a few months, was compliant with AA, had a sponsor, but did not have drug testing. I couldn't find a place locally for me. I asked Miss Burgess via email, and she asked me to use the group that I had previously used with Mr. Richards. I called that group on a number of times. They had sent me to supervisors. The supervisors looked my name up and could find that I was under supervision from Mr. Richards, and that in order to start back up, they needed authorization from Miss Burgess that this stuff had yes been ordered. And I never heard a response back from Miss Burgess, never heard back from the drug testing thing. And after a number of attempts, I gave up.
So I just want to break this out here.
Can I just finish? You don't have to. I'm almost done.
Sure.
Thank you. So after not receiving it, I have not done a drug test. I did not do affidavits moving forward. And I stopped going to counseling and have not gone to AA as much as I should have.
Sir, my original question was, did the commission take any action? Your answer is yes, right?
I think that I just explained that yes, they did.
So, and to make sure everything's clear, originally you and the commission entered into a contractual probation, right?
Is that the LJAP thing? I don't have the exact paperwork in front of me, but yes, I signed an agreement to be on a probation that was not public.
And at some point you violated the terms of that, right?
I did.
And at which point, after some negotiation with the grievance commission, you entered into a order of reprimand by consent with conditions, right?
Yeah, I believe that was in July of June of last year.
Okay.
And excuse me if I'm not getting the date right, but it was last year sometime.
Okay. And one of the conditions was that you were to submit quarterly affidavits to the Attorney Grievance Commission demonstrating your abstinence from alcohol and non-prescription controlled substances.
Yes. I believe I submitted one.
Do you have proof that you submitted that abstinence affidavit to the commission?
It would be on my desktop computer at home, the Word document. I can look in my email because I believe I emailed it to her. Let me check.
Mr. Blessing, Nelson, is it material at this point, given that there's already been the finding of misconduct?
Yes, but Mr. McDonough, let me continue with my questions. Did you receive and review the show cause motion that was filed, which the panel has granted?
Yes,
Are you familiar that aware that one of the allegations was that the grievance commission did not receive any absence affidavits from you between July 15th and January 18th of 2023 through 2024?
yes,
Are you now contesting that you did in fact submit an absence affidavit?
I believe I sent one.
And it's your assertion that you did in fact go to Alcoholics Anonymous?
Yes, for a period of time, and I have gone sporadically as well, but for a couple of months, maybe a little longer, I went in compliance with my agreement. I did not get any sheets signed or anything like that. This is just me stating that I did. And I could present evidence of me going for a couple of months, but I kind of thought that was not really all that important in the grand scheme of things.
So it's your position that you did go to Alcoholics Anonymous, but you didn't submit any proof fit to the grievance commission?
Yes,
And it's your position that you did have a sponsor?
yes, I no longer have a sponsor, but I did.
When is the last time you had a sponsor?
At the beginning of my agreement with Mr. Novi, it's the same period of time that I went to Alcoholics Anonymous and did not send you guys proof. I'm not denying that I didn't send any proof, but it was for a couple of months I was compliant. Then I got frustrated with the drug testing thing, and then I wasn't compliant.
What is
But
the
I guess,
name of your
okay, under my agreement, I was never compliant when it comes to that. I did not send anything to the grievance commission proving that I went to AA or that I had a sponsor.
who is the name? What is the name of your sponsor?
I do not have a sponsor now.
What is the name of your last sponsor?
Brad Penny.
Sir, do you recall a conversation you had with me where you said, I don't have a sponsor and I don't need one?
Yes,
Do you know, are you familiar with the 12 steps of Alcoholics Anonymous?
yes, I've been through and completed all of them.
Off the top of your head, do you know any of the 12 steps?
Yeah,
How many of them would you be able to tell us?
I don't know. The first step is admit that you have a problem and that your life has become unmanageable. Step two is be willing to turn yourself over to your higher power, God or your higher power. I can't recall step three. Step four is personal inventory. Step 5 is admit to your sponsor and another person your shortcomings. Step 6 is giving up everything to God. 7, I'm not remembering. 8 is the make amends to everybody you can, unless it's going to cause severe problems. I mean, I cannot remembering word for word.
And it's, oh, sorry.
I mean, if you're gonna be real picky about this, I'm not sure what my knowledge of the 12 steps at this point matters in this hearing. I've gone through everything. I was cooperative and went to hundreds of AA meetings that you should have proof of in your file. That
Sir,
were
when did you,
accepted by
when did
Dana
you go to
Richards.
these hundreds of meetings?
After my conviction for impaired driving. I submitted stuff to Dana for months and months and months and months and months.
Right, but we're not here today regarding the contractual probation. We're here regarding the order of reprimand. After that date, did you submit any proof to the commission about
No,
AA
I've already
attendance?
said that.
Why didn't you submit any proof of complying with the conditions?
I don't know, I didn't.
You said you attended therapy for a period of time.
Yes, you have letters from my therapist.
Why did you stop attending therapy?
I was not getting along with I didn't think the therapist was right for me. I know it doesn't matter now, but I've got an appointment with a new therapist next week in order to start things up again.
So when did you stop seeing your last therapist?
I believe the last time I went was in November of last year.
And why did it take so long to get a new one?
Because I was not in a good place, and I spent some of last year in and out of the hospital and other things, and was at a point where I wasn't practicing law much at all, and I don't know.
Okay. Switching gears, did you ever represent a Courtney Hite? And let me just spell that name. It's Courte, or sorry, Tney, last name Hyche.
It's pronounced Heish, and yes.
Okay. When did you represent her?
Last year.
And what did you represent her for?
A divorce.
I
believe it was the beginning of March or end of March of last year. Wednesday, March 29th is when she first contacted me.
Okay. And what happened with her case?
It did not get started.
Why didn't it get started?
Because I took on a case that I didn't have the experience I should have to handle, and I didn't know what I was doing, and I played stall and delayed tactics with her throughout the process, and then eventually gave her her money back. I feel absolutely awful about what I did to her. She's a very, very good person and didn't deserve to be treated the way that I treated.
Did you ever make any misrepresentations to Miss Hike during the representation?
I wouldn't call them misrepresentations. I was attempting to do things. I just didn't know how to do them right. And told her things that at the beginning I thought were done that weren't done properly. And then as I was trying to figure out how to do things properly, I guess, yes, you could call them misrepresentations.
Did you tell her that you would refund her if she withdrew her request for investigation?
I don't know what the exact words were, but I said that I'd be happy to refund her money if she would write a letter to you guys. The only thing I asked her was to write a letter to you guys indicating that I had paid her back, which she did. And you can, the text messages are in evidence. If I said something, please, I'm not denying that any of those text messages were from me.
Okay. So the text messages that are in evidence, you're admitting that they are accurate?
Those were my responses, yes.
Okay. So
I'm not denying that any of them were mine.
So you admit that on January 19th, 2024, you sent her a text message reading, "If I get you your $3,000 in the next 2 weeks, will you drop this grievance?"
I don't think she had grieved me at that point in time.
But you admit that you sent that text message.
Yes, from my hospital bed.
Okay. Isn't it true that you never filed an answer with our office to her request for investigation?
Yes, I've already admitted to that.
Why didn't you file an answer?
Under which case?
Specifically to the request for investigation, not the formal complaint or the show cause motion. Why didn't you answer the request for investigation?
I don't have an answer.
Okay. At this point, I don't have any more questions, but if he testifies later in his own case, I would reserve the right to cross-examine him. If the panel members have any questions, if not, I'm ready to call my next witness.
Okay. You excuse Mr. McDonough from the witness stand, such as it is in our virtual environment. And Mr. McDonough, you can call your next witness. Do we need to bring her in from the virtual waiting room?
I'm assuming you mean me.
Yes, I'm sorry. Did I say Mr. McDonough? I'm acting like President Biden here, getting names mixed up, right?
Yes, I would ask
Mr.
for a
Blessing
quick.
Nelson, would you like to call your next witness?
I'd ask for a quick 5-minute break, but yes, I would like to call Miss Courtney. I forgot how you pronounce her last name. Hike. But yes, and she should be in the waiting room. Heish.
Hi, Mr. Blessing Nelson, let me inquire, please, is the testimony from your next witness essentially cumulative to evidence and admissions currently on this record?
Some of it potentially, others goes to sanctions. However, as the complainant, she does my position is she's entitled to testify. She's indicated she wants to. And she has a right to tell this panel how Mr. McDonough's actions impacted her.
I understand. Okay, and so, perhaps Jody can put the panel in a breakout room during this 5-minute break that you've requested.
That'll work. Why don't we reconvene at approximately 10:56?
Thank you.
Okay, the panel is back. Just need Mr. McDonough. There he is. Okay, we are back on the record. Mr. Blessing Nelson, would you please call your next witness?
Sorry, I thought I did. I'd call Miss. I'm gonna mess this up. Heish. I'd like to call Miss Heish.
Okay. Jody, if you could let her in, please.
Ms. Heish?
Yes.
Okay, thank you.
Hello, Ms. Heish. Thank you for attending today's proceedings. I'm Lori McAllister, one of the panel members. We have 3 of us that are here today to preside over the case. Mr. Blessing Nelson has called you as a witness in the proceedings, so we are prepared to hear your testimony at this time, okay?
Okay.
First thing we're going to do is have you sworn under oath, and then the attorneys will be able to ask you questions, starting with Mr. Blessing Nelson's questions, okay?
Okay.
All right, great. Madam Court Reporter, if you would swear her in, please.
Would you raise your right hand, please? Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Ms. Heish, could you please state and spell your name for the record?
Yep. Courtney Heitch, COURTNEYHYCHE.
Thank you. How do you know Mr. McDonough?
He was recommended to me by a friend to represent me in my divorce.
And you retained him to represent you in that divorce, right?
Correct.
Did you pay him anything?
I did.
How much did you pay him?
$3,000.
Were there any issues with Mr. McDonough's representation of you?
Yes.
Could you describe them for us?
Yes. The divorce that I had hired him to represent me for, the paperwork was never filed with the county. There was a huge lack of communication. Multiple times I would try to reach out and would never get a response.
Did he ever fail to give you any updates about things that were going on in the case?
I received one update, which was at the end of May. And then after that, I received another update in July stating that he had served my ex-spouse, and that was it.
You mentioned that you received an update saying he had served your ex-spouse.
Mhm.
Did he actually have your ex-spouse served?
He stated that he had served him, and when I asked for a copy of the paperwork from Mr. McDonough, he said he would email it to me. However, he never did. My ex-spouse did send me a copy of it, and all it was the request for divorce, the initial paperwork that you filed to start the divorce process. That's what he served my ex-spouse with.
Okay. Did Mr.
Complaint for divorce,
McDonough?
I'm sorry.
Oh, sorry. Did
I'm
Mr.
sorry.
McDonough?
I'm sorry, but I didn't hear what you just said, ma'am.
He had served my ex-spouse with the complaint for divorce that I had filed with Mr. McDonough. That's what he gave my ex-spouse. So he didn't actually serve him a summons.
Thanks.
Did Mr. McDonough ever tell you anything that you learned to not be true?
Yes.
Can you describe those for us?
He said that he had filed the paperwork with the county to start the divorce process. However, he never did. When he stated that he served my ex-spouse, like I said, the only thing that he served him with were the complaint for divorce that I had filled out and signed with Mr. McDonough. And I called the county multiple times because he would say that he had filed the paperwork. The county had nothing showing that he had filed anything.
And when you say the county, you mean the court, right?
I'm sorry, yes, the court.
At some point, did Mr. McDonough's representation of you end?
I don't know if you could say end, but I think I just took it as he was not going to do the job that I retained him for. So I ended up doing everything on my own as far as the filing of the divorce and moving through that process.
And at some point you asked him for a refund, right?
Multiple times.
When did you first ask him?
Oh, I want to say September or October of last year of 2023. I could be wrong. Could have
Okay.
been before,
And-
that might have been after.
And why did you want a refund?
Because I had figured out that the things that he was saying were not true and that he never did file the paperwork with the courts for the divorce to be started. And in fact, when I realized that he was unfortunately lying to me about everything, by that time it had been 6 months. So then I just went and filed everything on my own.
Okay. And did you ever file a request for investigation with the Attorney Grievance Commission?
I
against
did.
Mr. McDonough?
I did.
Approximately when was that?
Maybe maybe October or November of last year. I apologize if my dates are incorrect. It's got to be somewhere around in those times.
Okay. And briefly, could you tell us why you filed a request for investigation?
Initially, it was due to the fact that he did not do the job he said he was going to do. And he was not responding to me as far as me getting a refund for the job he did not do that I paid him to do. I'm not going to lie when I say it put me in it affected my children and I, because the job he was supposed to do left us in a position to where we were still dealing with a spouse who was verbally, mentally, emotionally abusive, cheated. There were times he was physical. And it was really affecting our livelihood, because I was told until things were filed with the courts, I could not have my ex-spouse removed or make him leave, I guess.
When you asked Mr. McDonough for a refund, did he initially give you one?
No.
Did you ever receive a refund?
I did. Thankfully, I did.
Prior to receiving a refund, did Mr. McDonough offer to refund you if you withdrew your request for investigation?
He did. And I did take a little bit of time to respond to that because my biggest thing was I did not want something like this to happen to somebody else, to a person who maybe didn't have the resources or knowledge to move forward with getting, some type of refund, or, being able to do the things that needed to be done for them to have their case heard. And that was a huge concern of mine.
So approximately when did he first offer to refund you in exchange for you withdrawing your request for investigation?
In January of this year.
Okay. You said you took a little while to respond, but when you did respond, what was your response?
I think I did tell him yes, that I would withdraw the case. I did tell him exactly how I felt and the things that he had put me through for the last almost year. But yes, I was willing to withdraw it. And I have felt badly about this even being happening and it possibly affecting his livelihood. But I also have to think about myself and my children.
So just backing up slightly, when he first offered you a refund, was it the full amount that he offered to refund you?
Yes.
Okay, when he first offered you a refund, it was the full amount, but did he ever try to settle for less than the full amount with you?
Yes.
When was that?
In April of this year.
So prior to you getting a refund, he tried settling for less than $3,000 with you?
Yes.
Okay. And you obviously refused, right?
Yeah. Yes.
So after you received your refund, did you withdraw your request for investigation?
I did not.
And you briefly touched upon it, but what did you do instead of withdrawing your request for investigation?
I wrote a letter to the grievance committee explaining that he did give me a refund of the full amount.
And in that letter, did you say anything about what you think should happen to Mr. McDonough?
I honestly don't remember. I feel like I remember saying something along the lines of just not wanting something like this to happen to anybody else. And that I did, oh, I'm sorry.
Oh, no, you please continue.
And I did feel as if, and I could be completely wrong, this is just my feelings personally, that I did feel like the only reason that I received a refund was because he is running for prosecuting attorney. And that was the reason I got my money back.
Okay. You touched upon it a little bit, but other than what you've already said, did Mr. McDonough's actions impact you in any way?
They did greatly. I mean, financially, my children and I, due to other things outside of this, I do not receive child support, which is fine. It was my decision. But it affected me financially. It was affecting my job. It was affecting the safety of my children and I, because my ex-spouse was coming and going whenever he felt like it, coming into the house unannounced.
Did it impact the way you view lawyers or the legal profession?
No, I think we all have a choice, and sometimes we just make a bad choice, and I don't hold that against him or any other lawyer. I mean, sometimes things happen to people and we slip, we fall, and we make mistakes.
When you say you don't hold it against him, are you saying you don't think he should be held accountable?
I'm not saying that.
Okay.
I mean, I think everybody should be accountable for, their actions.
Okay, thank you. I just wanted to clarify that. At this point, I don't have any further questions for you, but Mr. McDonough or the panel may, so please don't log off.
Okay.
Mr. McDonough?
Had I filed to run for prosecutor at the time I paid you back?
I honestly do not know. I don't live in St. Joe County. I don't know. I can't tell you that because I don't know. I had heard that you had, but again, I don't know.
And, the only other thing I have to say is that I'm very sorry for what happened. You and I shared some very personal issues that we both struggle with, and I feel awful for what happened, and I'm very sorry. That's it.
Ma'am, we thank you for coming here today and telling us about the situation. And certainly you should not feel bad for reporting the truth. So we appreciate your attendance and participation. Thank you.
Thank you
you.
so much.
And you are all set and can log off from the proceedings at this point. Thank you.
Thank you.
Thank you, Ms. Heish.
Thank you.
Any further witnesses?
No, at this point, I would rest. All I have is argument, which would be after Mr. McDonough presents his case if he chooses to do so. So I would rest.
Mr. McDonough, do you have any witnesses that you would like to call on your own behalf?
I do not.
Okay. Mr. Blessing Nelson, let's move then to your closing statement.
Sure. Before I discuss the appropriate sanction, to briefly remind the panel of the key facts, Ms. Heish retained Mr. McDonough to represent her in a divorce case. Respondent failed to diligently and competently handle the case. He failed to communicate with her about the case and lied to her about the case. He also failed to respond to the request for investigation that was filed by Ms. Heish, and in fact, he improperly attempted to get it withdrawn by offering her a refund conditioned upon her withdrawing it. He did eventually refund her. However, Ms. Heish did not withdraw her request for investigation, not that would have deprived this panel of jurisdiction, but instead wrote a letter which is in evidence detailing how Mr. McDonough offered to pay her in exchange for refunding the request for investigation and expressing some other thoughts about it. Mr. McDonough, respondent also clearly and blatantly violated the terms of a prior order of discipline as set forth in petitioner's motion to show cause. That motion has been granted. To the extent any factual allegations in it or its exhibits may be contradicted by respondent's testimony, the version in the motion should be taken as the accurate one. The failure to comply with that order shows contempt and a lack of respect for the attorney discipline system. Regarding the show cause motion, the order of reprimand made it very clear that if respondent violated the terms of the reprimand, his license would be suspended for at least 180 days. Just as a reminder, the order of reprimand was entered by consent, meaning Mr. McDonough was aware of and agreed to all the terms of that order prior to it being entered. Regarding the appropriate sanction, as this panel is undoubtedly aware, the Michigan Supreme Court determined in Grievance Administrator v. Low-Payton 462 Mich. 235, that's a 2000 Michigan Supreme Court case, that hearing panels need to consider the ABA standards for imposing lawyer sanctions when determining the appropriate sanction to impose. Past discipline cases should also be considered to an extent. As stated in the preface to the ABA standards, specifically under the theoretical framework section, the ABA standards do not account for multiple charges. When there are multiple charges, the ultimate sanction should be at least consistent with the sanction for the most serious instance of misconduct, but might well be and generally should be greater than the sanction for the most serious misconduct. Regarding the applicable ABA standards, several apply. Under standard 4.42, suspension is generally appropriate when a lawyer knowingly fails to perform services for a client and causes injury or potential injury to a client, or a lawyer engages in a pattern of neglect causing injury or potential injury to a client. Arguably, standard 4.41, which calls for disbarment, could also apply. Under standard 4.62, suspension is generally appropriate when a lawyer knowingly deceives a client and causes injury or potential injury to the client. Alternatively, the panel could find standard 4.61 applicable, which states that disbarment is generally appropriate when a lawyer knowingly deceives a client with the intent to benefit the lawyer or another and causes serious injury or potential serious injury to a client. Standard 7.1 states that, standard 7.2 states that suspension is generally appropriate when a lawyer knowingly engages in conduct that is a violation of a duty owed as a professional and causes injury or potential injury to a client, the public, or the legal system. Under case law, standard 7.2 is the most applicable standard for failing to answer a request for investigation and failing to cooperate with the grievance administrator. A good case for that proposition is the 2015 board case of grievance administrator v. Susan M. Eifler. Eifler is E-I-F-L-E-R, and that is case number 14-54-GA. The case law, specifically that Eifler case, also states that in general, the minimum appropriate sanction for failure to answer a request for investigation is a 30-day suspension. However, that is only taking into account the failure to answer the request for investigation, and before considering any aggravating factors. For reasons I will elaborate on, or which have already been discussed, the appropriate sanction here, based on all the grounds of misconduct and weighing of the applicable standards and aggravating and mitigating factors, is actually a lengthy suspension, potentially even disbarment. Standard 8.1 states in relevant part that disbarment is generally appropriate when a lawyer intentionally or knowingly violates the terms of a prior disciplinary order, and such violation causes injury or potential injury to a client, the public, the legal system, or the profession. Next, we must consider mitigating and aggravating factors. In terms of aggravating factors, several apply. First, 9.22a, prior disciplinary offenses, applies here because, as the exhibits that have been admitted show, respondent has prior discipline. 9.22b, which is dishonest or selfish motive, clearly applies because respondent lied to Ms. Heisch in an attempt to keep money to which she was not entitled, and refunded her in an attempt to get her to recant. He also acted dishonestly and selfishly through his failure to comply with conditions of the reprimand. This matter concerns multiple allegations of misconduct, which makes 9.22d, multiple offenses, applicable. 9.22e, bad faith obstruction of the disciplinary proceeding by intentionally failing to comply with rules or orders of the disciplinary agency, applies for multiple reasons. First, respondent obstructed the grievance administrator's investigation regarding Ms. Heisch by failing to answer the request for investigation. Then he unethically attempted to get the request for investigation withdrawn. He also failed to answer the formal complaint and the show cause motion. I would argue that his attempt to get the request for investigation withdrawn also qualifies under 9.22f, which is the submission of false evidence, false statements, or other deceptive practices during the disciplinary process. It is also noted that some of the statements Mr. McDonough made today are contradicted by the evidence in record. 9.22g, refusal to acknowledge wrongful nature of conduct, also applies. 9.22i, substantial experience in the practice of law, applies because Mr. McDonough has been licensed to practice law in Michigan since the year 2005. 9.22j also applies because by refusing to refund Ms. Heisch until the point that he needed her to withdraw the request for investigation, he clearly demonstrated an indifference towards making restitution. In terms of mitigating factors, it is respondent's job to argue for mitigation, although I would argue that none of the listed mitigating factors are applicable here. Any order of discipline entered in this case should have certain conditions tied to it. Given respondent's failure to comply with the conditions of the reprimand, the only logical conclusion is that he is concealing substance abuse. To this end, he should be required to undergo an LJAP assessment. I would therefore ask that the order of discipline state that if respondent seeks reinstatement, he must submit an LJAP assessment no older than 30 days old with that petition. Additionally, the addition misconduct, specifically regarding Ms. Heisch, clearly shows that he needs some guidance about properly operating a law firm and handling client relationships. To that end, he should be required to complete the State Bar of Michigan's Tips and Tools for a Successful Practice seminar prior to reinstatement. Restitution is not necessary as Ms. Heisch has already been refunded. The order of discipline should make it clear that the conditions just discussed should be satisfied prior to him being reinstated. In conclusion, petitioner respectfully requests a lengthy suspension in excess of 180 days, conditioned upon successful completion of the Tips and Tools for Successful Practice seminar and completion of an LJAP assessment prior to reinstatement. Alternatively, disbarment could be found appropriate by this panel. Thank you.
Okay, thank you, counsel. Mr. McDonough. You're on mute.
Yes, I apologize.
That's okay. Everybody does it.
first and foremost, I believe the consent agreement that I went into with Mr. Novi, which is a part of the record, said that I could be suspended up to 180 days if I violated that agreement. Whether I'm wrong about the language, I guess, doesn't really matter. As to some of the last things Mr. Blessing Nelson stated, I take offense to a few of them. I've admitted to everything that I did wrong. Today, I didn't argue the admission of any of the exhibits. The primary reason I didn't respond, one, I didn't understand the process, which that's on me, I should have. And secondly, I didn't have really any arguments against what they were saying that I did. I am more than happy to complete the tips of a practice seminar that he wants me to do, but I don't think it matters. I don't intend on having a firm ever again. I found that I did not like private practice. Obviously, I wasn't very good at the divorce portion of that. I feel awful about what I did to Miss Heish. I've had a handful of other clients, and not that many, most of whom would tell you that I did an exceptional job for them. I represented my county as an assistant prosecutor and as the elected prosecutor for 3 terms, equaling 15 years. That's really what my passion is. The pandemic really played a role in my alcohol consumption, and I did have alcohol in my system. I was below the legal limit.
For the first time, we are hearing from the attorney representing a West Michigan prosecutor. Some are calling for St. Joseph County's top law enforcement official, Prosecutor John McDonough, to resign following a drunk driving crash. News Channel 3's Mike Kravstig has been following this story for us. He joins us live to tell us what the prosecutor's attorney has to say.
Yeah, Erica, McDonough's attorney is refuting some of the information floating around in the public. He claims McDonough never left the scene of the crash and that his blood alcohol level fell below the legal limit about an hour after the crash. In June, the Michigan Attorney General's office charged McDonough with drunk driving and having an open container. Police say McDonough was drunk when he crashed into this Lockport Township fence back in May. The police report says witnesses estimated McDonough left the scene for less than 10 minutes and came back. His attorney, Mike Hills, says he never left.
He pulled away and turned his car around and parked. He's the one that called 911 to have the police officers come to the scene, and he waited there and he cooperated.
Police say McDonough's blood alcohol level was 0.107, over the legal limit of 0.08. Dozens of local citizens presented a letter to the St. Joseph County Board of Commissioners last night, calling for McDonough to step down as prosecutor. Hill says right now McDonough has no plans to do so.
He has no intentions at this time to step down, but his focus really is on getting better.
I pled guilty instead of going to trial to take responsibility for my actions initially. I successfully completed my probation with the district court in Kalamazoo County early because of all of the work that I did, not only towards my addiction, but to make sure that I was staying sober. I then worked diligently with Dana Richards at LJAP for, I believe, a year or so, then had a relapse and went to rehab. At rehab, I spent the last 3 days of my term there in the hospital in North Carolina. Came home and they decided that I had to have my toes amputated. And so I had my toes amputated and I was forced to sit at home by myself. And I relapsed again. And that's when I ended up with the situation with Mr. Novi. what my actions have brought a lot of shame on not only myself, but my family and my wife's family and my community that I love very much. You know, there hasn't been much positive said about me in this hearing, but I am turning my life around. I've had extremely positive feedback the last few months since I've decided to run for prosecutor again. I believe I have an excellent chance of winning the primary, but I don't know after today if that's really going to matter. As to Miss Heisch's refund, it had absolutely nothing to do with her withdrawing her grievance or me running for prosecutor. I did it because it was the right thing to do. And I felt awful about what had happened to her. And the only thing that I asked her to do was write a letter to the grievance commission, which she did, stating that I paid her back. And if you read the letter, it wasn't positive towards me whatsoever. And again, reading that from her made me feel awful on top of that. But, you know, the bottom line is that I screwed up more than once. I would certainly ask that you guys take into account, you know, this is my livelihood, and I certainly haven't made any money really in the last few years because of the shame and the way people have kind of blackballed me in the legal community in my area. You know, I made $20,000 approximately each of the last 3 years. So any sort of expenses involved with me getting my license reinstated, if it is suspended, I would appreciate those to be as minimal as possible. But I'm willing to do anything. I'm in a very good place, as I said, this point in my life. I'm willing to do testing. As I said, I would need the grievance committee's help with that. And they knew that I needed their help with that, and it never happened. They have to approve for me to be ordered to get the testing through the place that they want me to. I'm happy to do AA. I'm happy to have a sponsor. As I said, I've already set up counseling again. And I know you guys may consider it too little too late, and that's fine, but I'm doing it to better my life. You know, if I were to be elected, I wouldn't take office until January. And that's when I would have to have my license to practice law again, which is a number of months away still. But I'm very, very sorry for the shame that I brought on the legal community and everybody involved with me over the last about 4 years. Prior to that, everything was pretty good, and I was very, very good at my job as prosecutor. I had very little issues in the past. I made one stupid public comment that I went to a media relations thing that you guys asked me 2 years ago, and that's, you know, really all of my experience with the Attorney Grievance Commission prior to this. I just, you know, ask you to look at the totality of my career, in that for the vast majority of it, I've represented this profession honorably. I've been a public servant for the majority of my career, and that's what I hope to do when my license is reinstated, is to become a prosecuting attorney again somewhere. But as I said, I am not making excuses for my actions, and I'm willing to accept whatever sanction you guys impose. I just hope that it could be under 6 months if you decide to suspend my license. Certainly, I hope it's not at all, and that you allow me to do extended probation and everything else to get this whole situation behind me. But certainly, thank you guys for your time this morning. And I apologize for my actions.
Mr. McDonough, where would you place yourself in terms of your sobriety at this point in time?
I would say it's in good shape, and I have the motivation now for the first time in a long time. Along with the alcoholism, mental health has kind of creeped in, and that's probably why I haven't answered things and other stuff, is because I've been depressed. I haven't had really anything to feel good about outside of my family. My career has been destroyed over the last 4 years, and I really haven't had the opportunity to be proud of myself. And, with all of the positive feedback I've had in deciding for run for office, and the fact that I know that I have to be in good shape and, sober, and, all of those things in order to successfully perform the duties of a prosecutor again, I'm motivated more than I have been since probably the beginning of my probation, after I pled guilty. After I got into the accident with the impaired driving, and then I had serious medical issues not related to the accident, and I had to took me months and months and months to recover. I spent over a month in the hospital, and so it wasn't until after I pled and I was physically feeling better that I was able to really get going, and I did. And you could look back at the records with LJAP. I went to hundreds and hundreds of AA meetings, and
I'm just asking about where you are right now.
I am in a very, very good spot.
Does that mean you're still drinking or not drinking at all?
Not drinking at all.
And how long has that been the case?
I can't tell you the day that I stopped.
Approximately?
A month.
Okay. Very
maybe a little less.
okay. Okay. Thank you for sharing your statement with us today. Mr. Blessing Nelson, you have the final word.
Thank you. I'll keep it brief. Well, I am definitely sympathetic to Mr. McDonough's personal situation. It is important to remember that the goal of attorney discipline is the protection of the public. In this case, given the conduct related to Ms. Heisch's case and the failure to comply with the prior order, which was necessary for the protection of the public, the appropriate sanction here is a suspension of at least 180 days in order to require him to go through reinstatement proceedings to ensure that he is fit to practice law again prior to being allowed to do so. That order should be coupled with the conditions I mentioned. Alternatively, a disbarment could be appropriate. Regarding the arguments Mr. McDonough made about the evidence of his compliance with certain conditions, or about what he did or did not say to Ms. Heisch regarding the request for investigation, I will say that that evidence speaks for itself, and I would ask the panel to review it. The letter and messages are in the record, as is the motion to show cause and the related affidavit and records related to Mr. McDonough's noncompliance with the order of reprimand. Regarding the fact that Mr. McDonough says he did attend AA or did have a sponsor or anything like that, it should be recalled that that evidence has not been submitted to the panel. And in fact, at least in part, the evidence that has been submitted contradicts that, at least regarding the relevant time period, which is not during the prior contractual probation, it was during this order of reprimand. What he did prior to that certainly was important on a personal level, but is not relevant for today's proceedings. The fact that he is running for re-election should not be considered. It's relevant. And frankly, if it were considered, it should not be viewed in a positive matter. That should all the more encourage the panel that the public needs protection and that we should ensure that before Mr. McDonough practices law again, that he is fit to do so. This may seem harsh and punitive, but as I said earlier, the goal is the protection of the public. Attorney discipline is not meant as a punishment, although some of the things may have a somewhat punitive aspect. It's the protection of the public. And in this case, based on all the evidence presented, a lengthy suspension or even a disbarment with conditions is necessary for the protection of the public, and that's what I would ask be imposed. Thank you.
Okay, thank you for your statements. I believe this brings the hearing portion to conclusion. We've got the exhibits all admitted, so I think we've tidied up the record. The panel will be taking everything under consideration and issuing a written opinion of its findings. Anything else from my fellow panel members before we adjourn?
Not for me.
Nothing for me. Thank you.
Okay.
I-
Thank you.
Could I ask one, as just inquiring,
Yeah,
how long do you expect the decision to take?
we expect 30 to 60 days, maybe sooner.
Okay. Okay, thank you. Thank you all for your time. Thank you very much.
Thank you.
Thank you. Have a good